I have the duty to mention one matter, my lord, which lordship direction was to come on the list on today's list, but it's not appearing, my lord.
No, today I have changed it because today I have criminal matters.
My lord.
So it will appear in the list in due time. Follow the list.
Monday?
I have to accommodate. No, not possible. I have to accommodate it because I have cut short my date for interlocutory applications. So I will check it and fix a date.
My lord, with regard to one parted matter, which your lordship was pleased to direct to appear today, my lord.
Give name.
My lord.
Give list. So far as inclusions are concerned, give list. Yes.
May I have the liberty to mention item numbers 10 and 11 at the time of my lord's rising if it is not taken up? Because today is the last date for the interim order. I will wait, my lord.
But I am appearing for the other defendant, my lord. Kindly, this has to be, the hearing has to start now.
Yes,
So long, my lord, order 7 rule 11 was going on. Now I think, my lord, they have to start the hearing of the injunction application.
yes, there is no difficulty. I was only wondering if it's not called on.
Let me check whether other matters can be finished before that.
Yes, and
Because
if not,
today is the resolution of 3:30.
yes. So if not, my lord, I'll mention at 3:30 and pray for the extension, my lord. Because today is the last date of the interim order.
All right, I will pass an extension order.
But a short extension.
Yes,
so that
yes.
your lordship, next week, your lordship kindly keeps it, my lord.
Not possible. Only 4 days are there. Next week, not possible.
I mean to say short date, my lord. Not my
That I will
lord,
check.
but I am being led by Mr. Dutt, my lord.
No, ask him how long he will take.
He is leading me.
Not in this matter.
No, this matter.
Not in several other matters.
10, 11.
4. Item number 4.
Oh, 4. 4 he has finished. He has to say, how long will he take?
Oh, now it's his turn.
Yes, my lord.
I've
given your lordship a brief background. We'll start today.
I'll fix a date.
And kindly extend the interim order.
Yes, I will extend. That I will extend.
Your lordship is over what
And what today is 3:30. Let me call the list first.
Yes.
Without waiting.
My lord, with regard to the matter I had mentioned, your lordship granted me.
Let us all of here kindly fix a date, my lord. Any date next week, my lord.
Next week.
But post Holy Week, 17th, 18th, any day, my lord.
April.
No. Please, my lord.
No, I can't accommodate. Please believe me.
I'm suffering and
I understand, but I can't accommodate you. See my dates. See my diary. I have to accommodate. I am not bringing in the list 30 interlocutory applications. I'm not just able to do that. They are yet to be accommodated.
Well, let us start one day. Your lordship gets a feel of the matter, my lord.
2nd April.
My lord, with regard
An
to
interim order till my lord 5th.
Adjourn to 2nd April.
Well, one day in March.
Not possible.
One day in March. We are one day in March.
দেখো একটা date.
পেয়ে যাবে, পেয়ে যাবে।
28 March. 31st March.
21st March. Very good date.
31st March.
31st.
Don't be too optimistic.
my lord,
31st March. At interim order is extended till date.
There's possibility of a holiday. 31st March.
31st. Oh no, not 31st March.
28th. Well, let it remain.
28. Yes. 28.
my lord, with regard to the parted matter, your lordship just
Give a
allowed, my
leave.
lord. My lord, I have
Request
given
if
the
it will
slip, my
come.
lord. Could this matter be Mr. Jishnu Shah is leading me in this matter, my lord? Could this matter be could this
Follow
matter
the
be
list, we will find the date.
in April?
Next matter.
Sometime in April, my lord.
Yes, April.
My lord, may I take a leave to mention, my lord, draw and complete the order and judgment, my lord. This is the judgment dated the 6th
দেখে নাও
September.
দেখে করে নাও। Yes, Mr. Chaudhary.
My lord, item 1, my lord.
Yes.
Item 1, I am for all the defendants except 24.
My lord, to relieve your lordship, my lord, of further problems, we have settled the matter.
Yes, your lordship. It's been settled.
The terms of settlement has been signed by the parties as well as the advocates.
And all advocates.
Possibly it is not dated. No, there is a date.
22nd January, lordship, last page.
Surprisingly, there is a date.
So that I don't have to answer difficult questions, I didn't open it.
Terms of settlement. This is CS 210 of 2001.
Yes, Milord. Yes, Your Lordship.
Terms of settlement are filed by the learned counsel. Full stop. The suit is accordingly
The EC 158 of 22.
ended in compromise. Let the suit be decreed on compromise. Terms of settlement. I think there is no typographical error or anything like.
No.
Have you checked it?
Milord, Mr. Mr. Sengupta has checked it. Milord,
Yes,
there's
sir.
no problem. Milord, only
Terms of
thing is,
settlement may be.
J numbers 14, 15 and 16 of 23 are disposed of.
Yes. Terms of settlement shall be part of the decree. The instant suit is disposed of along with pending applications.
I'm grateful.
I'm grateful.
Grateful.
Decree may be drawn up. Compromise decree may be drawn up.
Item number 2. Lord, in this matter, my lord, I'm for the plaintiff, my lord. Here also, my lord, we filed the terms of settlement, my lord. My lord, we don't want to bother you.
Without having any date.
No, my lord, it's dated, my lord, as I've checked.
Terms of settlement are filed by the learned counsels. The suit may be decreed on compromise accordingly. Decree may be drawn up. Terms of settlement shall be part of the decree. Terms of the settlement dated 26 February 2025 may be part of the decree. The suit is disposed of along with pending application, if any.
I'm grateful.
Grateful, Your Lord.
Item number 3 and 13.
Well, as item number 3 and 13 are connected, I beg to appear for the plaintiff applicant virtually.
Your Lordship, I'm led by Mr. K.C. Garg, and he is not available today, so I'm praying for no.
Manoj, may I make one request? This is Manoj the fourth time, Manoj, that a request for Manoj accommodation or an opportunity to file. Yes, now kindly first see the order of 21st of November. 21st November, then 6th of January, and lastly on 10th of February. And Manoj, may I say only one thing to satisfy your conscience?
You are for plaintiff.
Yes, I am for the plaintiff.
Whose application is this?
Manoj, this is the plaintiff's application.
Let me see the application.
Yes, now Manoj, I am so deeply obliged. Now, Manoj, kindly just Manoj, I will just show Manoj 3-4 facts. Because the Lordship will take up GA number 11.
This application is for?
Manoj, this application is one for restoration of the suit, that is GA number 10. And there is GA number 11, which is condonation of delay in filing for restoration.
When the suit was dismissed?
Well, this suit was dismissed on 4th of September 2023.
Grounds of?
Yes. Now, Manoj, on the grounds, Manoj, may I only show just 1 or 2 documents, Manoj? Kindly take up GA number 11, if your Lordships kindly pleases. And let's kindly see page number 23.
GA 10 of 24 is filed.
Yes. Now, Manoj, GA 10 and G.
Condonation of delay. GA 11 is filed. Praying for restoration of the civil suit.
Manoj, may I say it the other way?
Dismissed for non-prosecution, dismissed for default in terms of order dated 4/9/2023. Full stop. Copy was served. The learned counsel for the defendant number 1 is not present today, but sought for adjournment. Full stop. Next para. On perusal of GA 10 of 24, it appears that a plausible explanation is given for delay. Let the same be accepted. The civil suit being CS 7 of 25 be restored to the original file along with the applications. GA number 10 of 24 and 11 of 24 stands disposed of. The suit will appear in a list for further order on 23rd April.
23rd. I'm so deeply obliged. Only one correction. GA 10 is for restoration and GA 11 is for condemnation. Perhaps in your lordship's order. Yes.
You got the order, that's all.
Yes. I'm so deeply obliged. I'm grateful, Malaj. I'm so deeply obliged.
I will make corrections if necessary.
Yes, I'm so deeply obliged.
We are for the defendant number 3.
Very good.
Because in this matter, actually, we're not even wanting to prosecute the suit because there is only the release of bank guarantees. This is a very unique case.
So it should go to the commercial division.
Your lordship pleases, Manoj. Otherwise, according to us, it can be taken up.
Let the matter appear in the list on the next date. We'll decide whether to go to the commercial division or not.
Yes, all right.
Further order.
Yes, I'm so deeply obliged because otherwise, in this matter, the only reason, may I only take a second more? The only reason for restoration is I want my original bank guarantees back because I settled the matter.
Let it be restored. Come on.
Yes, I'm deeply obliged.
Item number 4 and 7.
This is our application for grant of probate. My learned friends, clients have also filed a partition suit regarding the same properties, except for 2 properties. Now, just like while we were waiting, Malad, we had a long discussion, suits going on for many years, Malad. Now, the properties that are the subject matter of the probate, there are plenty of properties, 13 odd properties, and 2 of the properties came from the mother. They have not disputing that at all. Of course, the probate has to be granted. This is I'm saying. So 2 of the properties, they have nothing to say that Mr. Gaurlal Mitro had inherited from his wife. So those 2 properties are out. As far as the other 12 or 13 properties are concerned, they have filed a partition suit. Initially, they took the objection in this probate saying that these cannot be the subject matter of the probate because Gaurlal Mitro was not the owner of these properties. Then, being advised properly, they filed a partition suit because, as your lordship knows, sitting in the probate court, your lordship doesn't decide title. There are 2 main points that we took. One is that your lordship will not decide the title. So even if I granted probate, if I prove the attesting witness has proved the execution of the will, probate will be granted. That I don't become the owner necessarily. And now there's list pendants, the partition suit is pending. The second point is, if they contend that these properties are not the properties of the testator, then they are claiming adverse. Their rights are claiming adverse to the property of the testator. Then that caveats have to be discharged. So they have no locus standi to challenge the will, at least as far as 13 of the 15 properties are concerned. So our first point in reply will be, we will prepare our notes and we are trying our best to see that it's amicably settled. Mr. Dutt's also put there, we spoke. 1 or 2, since it's a large family, 1 or 2.
No, one thing, Mr.
1 or 2 parties are not agreeing. One party, rather. One party. It's only one sister who is just not willing to talk to us. So that is the thing. So after that, because there's the partition suit, we can always settle the part. Your lordship knows probate is very difficult to settle. The terms of that
Either I have to allow probate,
yes,
or I have to refuse it.
Yes,
No
so that
second, third
they
option
can
is
do
there.
by agreement because the properties they are disputing, all of them, even the person who's not settling, my lord, the properties they are disputing are the subject matter of the suit. That's item 7.
In that case, once you settle the matter, you have to withdraw this application.
No, probate, I'll have to file that terms of settlement. Probate will be granted and the terms will be kept on record. And in the other suit, it will be decreed. So then there's no 1/5 each. If there are 5 of us.
Because I cannot say probate, partly probate can be granted. No. There is no scope.
Yes.
Either to grant or to refuse.
That is the matter of agreement. If they agree to that 1/5 sharing, which is the most practical thing, it sounds, of those properties, then they'll say that you can grant probate. It will be in respect of the properties which they are now having no claim over. So I'll still have a probate on that. So these were the two main, the bone of contention, whether they can challenge this probate at all. The other points, there's another very interesting point that arose. This is concerning, it's a very subtle point. The will is dated 28th of February,
Date of this
2001. Now the
one thing,
date,
Mr. Ghosh, do one thing. Try for some other day.
Hmm.
If it is settled in the meantime, you will be able to confine your argument to the more short
yes,
compass.
Very-
Because
that
possibly,
is
Mr.
Where's Mr. Dutt?
Engaging another court. I have
Mr. Dutt may withdraw his caveat.
Yes,
No,
that is the
yes, he'll withdraw the caveat, we'll file our terms, no one will be
There
deprived.
cannot be terms of settlement in this matter.
No, Your Lordship, that there's this case, the Carapiat's case, 1961, Calcutta, 359.
Yes.
So that says how a probate proceedings can be, probate has to be granted or not granted. That's the only option, my lord.
Absolutely.
But the terms is kept on the record, and if anyone violates the term, a separate suit or an execution proceeding can be, a separate suit can
That
be
is only
filed.
for keeping in record.
Yes, so that it gets the sanctity of court. It's like a decree.
That you can file in the partition.
And in our case, there's a partition suit, so there won't, but it'll take them some time. I asked them to at least tally which properties, who wants which properties, or how is the amicably, if some properties can be sold, and the person who's not cooperating,
Money can be shared. Some property can be sold, money can be shared.
money can be shared, etc. So those let them decide, since
or by way of allotment, 1%.
Whatever that might be, any convenient mode can be adopted.
and my lord, I'll come back. Your Lordship will keep it in April. We'll come back.
Yes, because the matter is settled. You may withdraw your caveat. That there is possibility.
No, no, the settlement is always on the card because these parties will, this litigation will pass on to the next generation. That has to be avoided.
I think
That can be.
Mr. Jishnu Chaudhary's submission on the one matter before that was inspiring. That will file our terms of service. I don't know when that day will come, because there are 20, like at the 13 or 14 properties. I don't know, but
1 month time or less.
1 month.
Milord, may I say this, Milord?
Lordship make some observations.
Milord,
Observations, some, so that at
What
least
is
the
that?
persons,
The learned
the
counsel
persons
for the
who are not
parties
cooperating, that they come to the
submitted
table.
that terms of that
Only one party.
amicable settlement of all the disputes is in offing and prays for adjournment. Accordingly, hearing is adjourned today, 7.
এটা তো হবে না আরেকটু পড়া
21st April.
no, Milord. Milord,
shorter time
little
It will
shorter
get
time
later.
And
and a,
learned friend is
and a
saying
little
a few more words of encouragement,
yes,
stronger
stronger
words of
words of.
encouragement. It's not-
Otherwise, Milord, I'll tell you, Lordship, Milord, candidly, what is the problem? The problem is, Milord, I have 2 or 3
I
responses.
understand. I have to throw.
Yes.
That
so
is
that
the
I,
issue.
so that I can insist that this is a desire of the court also.
5th May.
No, no, not on the question of time. Lordship, shorten the time.
I will pass that order.
Yeah.
Just give me time. 5th May.
Milord, a shorter time because if it fails, Milord, then
will be there.
After the 20,
Any
21st April.
21st April.
as
21st
to be
April.
mentioned or whatever.
Parties are expected to settle their dispute amicably. Since
It's been pending, my lord.
this
from
is the family matters
2005.
and pending for lot.
Yes.
For long. This court expects that the parties should be able to settle their dispute amicably. Is it okay?
Yes.
I cannot pass any further
No,
order.
no, Milord. To start with, this is
Yes, sir.
I don't know.
What happened here? Okay. Is it good now?
Yes. I couldn't stay at home.
Yes.
I was confined for about 2 weeks. The only thing, Milord, Mr. Surojit Mitra, my leader here, was addressing your lordship.
Hmm.
I usually do not ask for any time. Kindly, Milord,
Absolutely.
some other day.
Ninth April is okay?
Yeah.
Mr. Chatterjee, 9th April?
What am I learning? Senior private surgeon. Yes.
Sir, you are here. No, not this matter.
I'm sorry, but maybe on 10 instead of 9.
Didn't take it. Hard in part, keeping it hard in part. Hard in part adjourned to 10th April.
Item number 6.
I prefer the plaintiff. Mr. Ghosh was making his submissions.
That horrible matter. Where is Mr. Mitro?
Mr.
Mr.
Mitro
is on his way. He's
That-
coming.
I'm telling you simply, this is a horrible matter. This is a horrible matter.
Interesting matter in the sense, my lord, my learned friend's client has now.
You just think how many, what I have to draft, one plaint, and how many written statement I have to draft. Then I have to come to the main question.
One thing, it might make it shorter for my lord. My learned friends, the plaintiff's, learned friend's clients, the plaintiff filed another suit in 2015 relating to the portion of the flat which they had reserved their right under the 2001 suit. They had said that one portion, there was already an earlier decree, so they didn't include it. Now they filed another suit in 2015. In the 2015 suit,
In the same floor.
same floor, now the one
But a
other
different portion of the same floor.
there are two more written statements in that. So, Malas, they did this. Then we have pointed out in our written statement here as well, that defendant number 1, the partnership who has been pleaded as a partnership and been dissolved in the year 1995. So there's no entity. Defendant number 1 is being implemented as a registered partnership first. My written statement in the suit when I filed in 2001, I have said that it is sole proprietorship. So then, in the 2015 suit, they implemented me as a partnership in spite of that. Thereafter, good sense prevailed. They said that we have informed them that which is not a it's not a partnership, it's a proprietorship. And they took out an application for amendment, which was allowed as recently as in 1st of March 2020. There are two suits. In the other suit, they have admitted that the defendant number 1, this suit is no longer in existence. I want to bring that on record. As far as defendant number 2 is concerned, that company merged with a third company in 1998. We have informed them. They've made defendant number 2 a party in the suit in its old name, and they have not claimed any relief against them. So the defendant number 2 had merged with one JP.
So that application is to be filed.
Yes, so this application, I want to bring on record by making an application. Their application for amendment is their pleadings that these entities no longer exist. So if they have chosen not to carry out the amendment.
Have you filed that application? No, you will file.
I won't file, but only on the 1st of March this order has been passed. Now reading their petition, I'll bring
1st of March of 2024.
You file it
for 2 weeks.
All right. Adjourn to 28 March.
No, I'll click that.
Unless that is filed, I cannot pass the order. Let the application be filed. I will pass direction. 28.
Item number 8.
31st কিন্তু holiday থাকবে 31st holiday থাকবে. Yes.
Item 8.
Who is the defendant? So you start argument first.
After an argument, but I'll be very candid for my thought during I know we've already covered that the sale agreement was unstamped. So that needs to be impounded. So accordingly, we have referred an application for impounding of that agreement, Lordship, so that we can proceed with the argument. Because now the ruling of the seventh bench is that
Have you gone through it?
Yes,
Once it is admitted that
Once
very
it is
clear statutory provision, once it is admitted, you cannot do that. See, section 38.
This is
Till it is admitted, it can be impounded. But once it is admitted, it cannot be. No judgment
cannot be any
against that.
judgment.
7 judges
settled.
bench decision. I have read it. Justice Sanjeev Khanna's corollary. It's very clear. Once it is admitted, 3 judges bench decision is also there. 4 judges bench.
this document when it was admitted, the admission was done ex parte because their documents when it was admitted, the defendants were already said ex parte.
When there is no qualification, once it is admitted, it will gone.
It is admitted.
You cannot raise this question. What you can argue, the evidentiary value of the judgment, this document is nil or nothing or something like this.
But my lord, even then, my lord, this
Although you can file an application in this respect, I cannot bar you in filing the
but there
application.
is an application. Lordship, my prayer will be to dismiss it with costs.
Application, have you filed application?
Yes, there is an application for impounding a document post exhibiting the document that was in maybe 2013.
Would you like to file an AO?
No, my lord, this is a frivolous
Fixing
application.
a date for hearing.
Lordship kindly dismisses it. Because there cannot be any judgment for in November the cross-examination was finished. The
Court did not
section was finished.
impounded it. That particular court did not impound it. Then it is duty cast upon that officer or that person.
Even this is for collateral purpose. I am not seeking specific
No,
performance
not
of that
collateral
degree.
purpose. Unstamped document cannot be.
Even assuming.
There is a difference.
Even assuming.
Any other purpose, the language, any other purpose, it's very clear. It cannot be used for collateral purpose for which an unregistered instrument can be used. That is the difference.
Lordship fixes it for hearing, my lord, for the main suit for hearing and dismisses this application. There is no merit.
Fix 17 March for hearing.
Let them move this
Date
application.
10 of 25. Affidavit in opposition, if any, shall be filed in the meantime.
Lordship kindly records I do not wish to file, and this is on point.
Come on the next date. I will give you opportunity.
Very well.
Don't say I won't file. Because some new counsel may come and say, no, it should be. Don't do this.
Great.
Item number 9.
Death certificate is K. Death certificate is exhibit K. How many death certificates are there? 1. What about the other death certificate? Shubit Palchut?
It's not disputed.
Who deposed in this case?
He declined. The signature. Shah is one of the attesting witnesses.
Who deposed? He identified his signature.
Identified his own signature.
And see?
That of the other advocate. Identified the testator.
But possibly he could not identify the signature of the testator, so far as I can remember.
He did not. He said it was not signed.
So your point was someone else. Someone else who have signed him.
No. My case is that I am
You recited one judgment.
that has been accepted. Will has been proved.
No, you refer to one recitation.
Yes.
Where is that? 2003.
That has been referred to in the later judgment. You will not refer to this. Action.
Section 71.
It's a
Any other judgment?
no, your lordship referred to me to judgment disputing 2015 volume 8 Supreme Court cases page 615, and your lordship wanted me to consider this before I make my speech. So I got it.
Yes.
Well, this is a case where the witnesses failed to, not a case of the witnesses saying that we do not remember or declines. Therefore, 71 can be invoked only on two cases. Where the witness declines or is unable to state that he remembers it. This is the distinction as between the judgment that I have cited and the judgment your lordship referred me. The lordship takes the judgment reported in 2015 volume 8 Supreme Court case.
Yes.
In the case where the witnesses fail to prove to bill. The lordship will kindly come to paragraph
'You refer to Jayantu Kumar Bhoyer,
yes.
Narayan Namdev Kadam,
Paragraph 90 of the judgment at page 625. Or has been considered.
Sir, give me some other days, some 7 days time. I will go through it.
No, I will only make.
I'll be very candid because I have some other suits I am writing right now. Give me 7 days time. Paragraph
51, page 636.
636.
This is the distinction between Janakina and God and this
52, you said.
51.
1, 2, both.
1, 2.
All right.
May I read it to you?
No, I will read it. I will study it. I will come on the next date. Next day I will reserve it. Hard in part adjourned to, because I will get 3 or 4 days holidays during Holi. 18 March.
The lordship will deliver judgment or
No, just hearing. If I need clarification, that is only for that only.
Lord, I have
Because if I think something different, I should disclose it to you.
Lord, only thing your lordship may.
And if I think you are agreeable, I will simply put it I will reserve it for judgment.
Lord, only thing, Lord, the judgment I have considered, your lordship had directed me. The main distinction between Janakina Court and this, that here the witnesses appeared, gave evidence, failed to.
I'll go through it. I'll go through it and check. Yes, Mr. Bhattacharya.
Item note 12. You can keep a copy of the dates also.
রেখে দাও চেম্বারে পাঠিয়ে দেবে No, that cannot be. We have to study a lot.
Life starts and ends with studying.
We are always in black and white. We have no color.
Come what may.
Colors are exception. Vokalottama was filed by defendant number 1.
But they have taken out an application now for acceptance of, my lord, the written statement.
Lordship, we have filed an application being GA1 for acceptance of our written statements. Lordship, the written statement is with us. This application needs to be allowed because the written statement
I
is
need
being
to file
filed
an objection, my lord.
beyond 90 days
EP1?
period.
What is EP1?
My lord, EP.
That is the main application.
That is the main
That's the
application.
main application. My lord, that's it.
Now the question is whether all are served with it or not.
Service তো হয়ে গেছিল না last day? Yes, yes.
I have to then obtain a report. Report from the department.
My lord, there was a report which was filed by the learned registrar original side dated 30th of January 2025. My lord will find it. My lord has recorded that in my lord solemn order dated 31st of January 2025. আগের ওটারটা? আগের ওটা? হ্যাঁ। Yes. My lord, there was a direction for paper publication also, my lord. So,
Is
my
it
lord
done?
has, yes, yes, 3rd of January, my lord has recorded that also.
This is application filed by
But the application at the
Defendant
instance
number?
of my
This
lord,
is an application filed by us. We are the respondent
Us
number
means who
one.
is-
at the
Respondent
instance,
number one.
at the instance of the returned candidate, my lord, who happens to be the respondent number 1.
এটা তো GA1 টা তো
Would you like to file AO?
My lord, I will. Because, my lord, admittedly, on the face of it, my lord, it is barred by time, my lord. Because even if we
GA
take
number 1 is filed by
ঠিক আছে my lord has given grant.
defendant number 1.
1,
Yes.
different number,
Defendant number 1.
respondent number 1, my lord. There it's-
Respondent number 1.
Fine.
Praying for leave to file written statement. Full stop. Mr. Bhattacharya, learned counsel appearing for the petitioner, prays leave to file affidavit in opposition. Leave is granted. Affidavit in opposition shall be filed within 3 weeks.
Grateful to your lordship.
Semicolon. Affidavit in reply, if any, within 2 weeks thereafter. Let the application appear in the list.
Record is WS টা file করেছি
My lord, here I am appearing for section of 14, my lord. Petition Commission India, my lord.
কবে করবে? 23rd April.
My lord, may kindly make it 4 weeks, 2 weeks, 6 weeks, and
6 weeks means yes.
instead of 3, 2,
your lordship would kindly
4 weeks and 2 weeks.
4 weeks and 2 weeks.
4 weeks and 2 weeks.
Lord, your lordship would kindly record that the written statement is not ready since lord the leave is pending. Lord,
Whether it's ready or not, that's not the
under
issue.
the-
Issue is whether I will allow it.
Lord, your lordship has on
Under
the
the- it is under
earlier
the
occasion,
original
Lord, your lordship has granted me leave to file
Sir,
wakalatnama. The wakalatnama was filed later on.
That doesn't mean I will allow you.
No,
It is for hearing.
Lord, there are
No, no,
some
his application in fact
কবে
makes my
date
case
বলো?
better.
6 weeks বললাম না?
his statements make my case.
মেতে দাও।
No, it's not like
29 কি?
court has some
29 April is okay. 6 weeks it will be. 29th April.
I am always there at your lordship's beck and call.
My lord, my appearance will
from
kindly
West
be
Bengal,
recorded,
but
my lord.
Grateful.
Oblige me.
My lord, my
One
lord,
thing- one
appearance
thing
be
more.
recorded kindly.
Other defendants have not filed any written statement. Full stop. Paper publication was made কবে হলো দেখো তো?
3rd of January, my lord had recorded it.
Recorded, but actual paper publication Where paper when it was published?
No.
Okay. Paper publication was made on 20th December 2024.
20th of December.
Yes, except respondent number,
Respondent number one.
One. No other application is forthcoming, praying for leave to file written statement. Accordingly, except respondent number 1, the application will be heard ex parte against all other respondents.
Grateful to you,
My lord, respondent number 14, election commission, India will not file any retention, my lord. I will not file any retention.
Oh, the
Very good.
period is also going to make that submission.
Don't trouble yourself.
Yes. No. I will not file any, my lord.
But they are holding every document.
No. Who is
I
saying
have
so? I am
passed
holding, my
order
lord.
of ex parte, whether you like it or not. This is ex parte hearing.
I understand my learned friend is justifying his appearance, my lord, by saying no.
Learned counsel for
I'm
the
grateful,
respondent
my
number 14. It's not okay?
Yes, my lord.
What he wants.
Submitted that respondent number 14 doesn't want to file any written statement. Be that as it
Yes, my
may.
lord.
Now it is effective for my learned friend.
Yes.
Grateful to you.
Effective for something
I am
else.
grateful, my lord.
Secured me.
I am grateful, my lord.
Item 14.
Yes.
Who
Who are you?
I appear on behalf of the petitioner, plaintiff.
I am on behalf of the defendant.
Yes,
What is the status?
The status is that the application is
This is
ready.
CS Com. So it should appear in commercial list.
No, your lordship, this is an old CS.
Old CS Com. What happened to it?
It is not a CS com. My instruction that is not a
It
CS com.
CS 31 of 24.
Yes.
Then
not a commercial-
old CS number 84 of 2018.
It's just been renumbered. It's not a commercial certification.
Order sheet গুলো দেখি। Wrongly it was transferred, possibly. Yes, the suit is for?
This is suit is for money suit. They have claimed money arising out of an agreement for purchase of our land.
Individual.
The
By any-
plaintiff is a company, private limited company, and the vendors are individuals, two ladies.
So what is the status of the suit? WS is filed?
Your Honor, if you kindly refer to the order dated 4th April 2023.
You are defendant.
I am the defendant.
Have you filed WS?
Yes, we have filed WS. That was prior to the COVID period. Immediately after COVID.
What about discoveries and inspections?
Since that time, it is held up and they are not cooperating.
Discoveries and inspections are yet to be made.
Your Honor, just one submission.
I'm not your Honor.
May I?
There is
Your
address
Lordship,
on be followed in
I
on the last occasion,
I
Your
apologize.
Lordship, I had taken time.
Discoveries and inspection. Would you make discoveries and inspection?
there's an
Otherwise, I'll close
There
it.
is an application pending without moving which I cannot proceed. That is because the the defendant number 1 has passed away and is recorded in one of your lordship's order on 3rd September 2020.
No application is in the list.
No, yeah, that is her heirs are already on record. On the last occasion,
Where is that application?
It is, lordship, it is ready. It has to be affirmed. It is an application for expunging.
Whatever that might be, whether it is to be expunged or not, documents are to be disclosed.
Absolutely, lordship. I am praying that
My lord, may I submit, my lord, only one submission, my lord. Immediately after COVID, since we could not attend, so there was a cost of 10,000. Thereafter, the discovery was ordered on the same date, subject to payment of cost, which we have paid within the prescribed time limit. After
Discoveries
that,
and inspection
dates
of
after
documents
dates they are taking.
Shall be made.
And they are more interested with one criminal case which they have filed. They are appearing on each and every date.
On or before 2nd April.
Your lordship, subject to being corrected, lordship, until and unless the application is on record, I will not be able to. Me being the plaintiff, I have to rectify the defect
The
first.
application is in effect expunging the name of one party.
It has not been affirmed yet. That is what I was submitting. Your lordship.
Suppose it is affirmed.
Yes, your lordship.
Prayer is that to expunge the name of it.
Absolutely.
How it is related to discoveries and inspections?
So, lordship, with the discovery and inspection, if I have to offer discovery and inspection, it has to be to the parties. Since I am saying that the defendant number 1 has died, it has to be expunged
Or
first, otherwise
substituted.
it will not be substituted. The legal heirs of the defendant number 1 is already on record. That is why I was saying
It
that
is
the
offered to the other person.
kindly gives me an
I will not
accommodation for
allow.
No, no.
My lordship,
I
They
will
have
not
other
allow.
intentions.
Come with the application. It is not yet to be filed. File it, then I can
your
hear.
lordship has recorded it in an order.
Since last 2 or 3 years, opportunities were given to you for discoveries and inspections. You know what are the consequences?
I am aware of the
That's
consequences,
all.
your lordship. I have to inform your lordship. This is because of a
This is not filed, so I'll not
unforeseen
take it to
event and not at the fault of the client.
I fixed the second appeal. Comply with it. Yes.
Much obliged.
Grateful.
I apologize for